Good afternoon, everyone. If I can welcome everyone to the webinar on part 36, and I just spent a few minutes there waiting for people to join. We've got 1,000 people joining, and it does take a bit of time. So today we're looking at developments in part 36 since February 2022, and the relevance of that date is the date I last did an update on part 36 cases. And if today you watch the webinar, I'm sure there's a case recently which hasn't been touched on. The answer may well be it isn't that recent. It often happens to me. It's over a year ago. And if you go back to this webinar from February last year, you will see the YouTube version of that webinar. It's still universally available, which deals with basically part 36 cases in the previous 18 months. So the probability is the case you're thinking of isn't as recent as you think it, but it's all caught up in that. And remember, I think the PowerPoints are going to be sent out to you. You can ask questions, which I'll get to at the end. And this webinar will also be on YouTube afterwards. So if you feel the need to watch repeats, you can watch it again or recommend it to your colleagues. And the thing about part 36 is this is just stuff you've got to know. You cannot be doing civil litigation without having a very detailed, up-to-date and accurate knowledge of how part 36 works. And looking at recent cases and all the issues arise is the best way of keeping yourself up to date, making sure that you don't fall foul of any problem when you make offers and fall foul of any issues when you receive offers. And it's a central part of litigation. But I want to start off by looking at recent cases about technical issues about the validity of part 36 offers. And people will take technical points. I'll come back to this later on. People will take the most extreme technical points sometimes because the consequences of not failing to beat a part 36 offer are also major in a lot of cases. You have to be aware when you're making offers, in particular, they have to be technically correct. Otherwise, someone will be looking for a way to argue this was never a valid offer. We see examples of this in coloured now. The defendant argued the claims offers were not properly served. Without valid service, there was no valid part 36 offer. And the argument was, that the email, the offers were served by email when the defendant solicitor had not consented to documents served by email. And the defendant may technically have been right. But if we don't consent to service of documents by email, the part 36 offer cannot be invalid. What the judge said was that there was no need for the court to make an order. However, if he did need to make an order, he would have dispensed with service or made an order on the CPR 3.10 setting, putting the issue right. Because there was no question of the defendant being prejudiced by the fact that claimants offer was sent by email rather than by post. So I agree, claimant's counsel, that to invalidate the claimant's offer on the basis of defective service would be a trial for form over substance. But that shows two things. It shows the length to which people will go to argue that offers that they got on the offers responded to were not validly served, and how you have to be careful, because although the claimant was successful in that case, you are relying on the court's discretion, and I'd rather not be. So be careful anyway about the form in which you make an offer. Check if there is an agreement to accept service by email, and if there isn't, I would put it in the post anyway. More recent case, or other technical arguments about part 36 was this. There's a case where there are a number of dependents in a very acrimonious family kind of property dispute. Two defendants were served at a part 36 offer, which they failed to beat and had all the consequences was worried about. Well, one of the defendants, who basically dropped out of the action and said, I had never been served with this part 36 offer. And the defendant said, although the offer was wasn't addressed to the third defendant, you have to serve all the defendants in order to have a valid Part 36 offer. And what the judge held was that this was a valid offer. There's nothing in the CPR which prior claimed to serve a Part 36 on all the defendants. There was nothing to accept the relevant defendants from accepting the offer in full and final settlement of their claim, or seeking a contribution from the other defendant. So that offer, for that reason, was valid. But then they said the offer was made too late. The trial was due to start on the 6th September 2022. The 5th of September was put aside for reading time. If the trial started on the 5th of September, the offer was made less than 21 days before the trial and therefore wasn't valid. The question was when the trial start, and the judge said the notice for trial clearly states it takes place on the 6th of September and refers to judicial reading time set aside on the 5th of September. The parties not being asked to attend on that date. And so the judge said the fact that in advance of trial bundle prepared and lodged for a day's judicial reading didn't mean the trial started on that date. And even if it did, said the judge, on the facts of this case, I would have abridged time. So that's one a technical issue, two technical issues there in relation to the validity and effectiveness as part of the offers. And the point I want to make, and I'll make it several times in the course of this webinar without any apology at all, is that you must make sure that your offers are made on time and are properly served, are effective and do comply with the rules. An interesting case about the technical aspect of Part 36 offers was a case of Monday and TUI at UK. The claimant won national personal injury damages. The claimant made two offers, one for $2,200 and the other for a 90-10 split on liability. The defendant made an offer of £4,000 and the claimant didn't beat the defendant offer, and then judge ordered claimant should recover costs up to the date of expiry of the Part 36 offer, claimant to pay defendant's costs thereafter. And the claimant argued, well, hang on, okay, we didn't beat our offer of £20,000, but we did beat our offer on liability. We got 100% on liability. And so it argued that in front of the judge of first instance and argued on appeal. And on appeal, the judge said, well, I don't really understand what you're about. I don't think this 90-10 liability offer can be fitted in the terms of CPR. Trying to do so strains the language of the mechanisms of the provision and leads you to strain in the misconstruction. So if you have got a case, and I see this a lot that way, that you've got an issue on damages and liability, and they're both going to be tried together, it's very doubtful whether any offer on liability will help much. The court's concerned with the overall effect, and not just an academic issue as to, well, if you'd accepted that, you'd be paying a bit less. Another issue on Part 36, part of the technical issues you've got to consider, is what happens if you make a mistake on the Part 36. In the case of O'Grady last year, basically the claimant brings an action for damage under the Fatal Accidents Act, and the claimant first sent a Part 36 offer, and it meant to concede contribution negligence of 20%. Inadvertently, the offer said 80%, and it said, well, they've promptly accepted by the defendant. And then there was a bit of a do, because the defendant's the issue was how obvious was the mistake, and the defendant's solicitor was summoned to court by the claimant to give evidence, presumably cross-examined about the obviousness of the hearing. But very shortly before the hearing, the reasons are totally obvious, really. It was conceded by the defendant that the mistake was of a type that would reach the agreement, render the agreement void if the court found that the doctrine of mistake applied the Part 36 offer. So we've got an obvious mistake, and as conceded by the defendant. The question is therefore, does the doctrine of mistake apply to Part 36 offers? And the judge said, yes, it does. So when a clear and obvious mistake is made, and this is appreciated by the Part 36 offeree, the point of acceptance, authority is entirely in support of the application of the doctrine. The fact that Part 36 is a self-contained code doesn't mean that that's excluded. So again, the crucial point to note there is that it's got to be a clear and obvious mistake. If they meant to say 20 will put 13, that may not have been a clear and obvious mistake, and the claimant may have given away 10% in contributing income you shouldn't have done. So just be very, very wary when you're making the offer. Do check they do reflect what you're saying, because not difficult to see circumstances in which that same scenario wouldn't have been clear and obvious. Another technical issue in relation to Part 36 offers is, can the court extend the time to accept Part 36 offers? And that was a matter considered in the case of Begum and Bots Health. And what happened there was an action was brought, declared negligence, evidently admitted, causation denied. Part 36 offer was £100,000 was made. The claimant said, I can't quantify this case, it's going to take years, and requested an extension of time beyond the 21 days for acceptance. And the defendant refused to accept time and extend time, but said you can still accept. So the claimant made an application to the court for an extended time for acceptance without the normal cost penalties. And what the judge found was there was actually no power under Part 36 to make the order sought. There was no power in Part 36 and no power anywhere else in the rules. So what also the court's got general case management powers to extend time. Then what the court said, no, that doesn't really apply. It doesn't apply at all in Part 36 at all. To adjust the time for compliance, not to adjust periods of time otherwise featured in the rule. There are some other important parts of that judgment as well we need to know about. The argument that there's an additional facility for the court to make a similar decision, but on a preemptive basis, is unfair. It's unfair to the person who makes the offer, because then he then fetters that person's right to withdraw the offer without permission of the court, and it increases the defendant's cost exposure in a way that it emasculates the cost effectiveness and significance of making a Part 36 offer. And the argument that some kind of residual discretion in the court, otherwise, to argue, really would undermine a large part of the purpose of Part 36. Now, we'll look in a bit more detail, actually, about the arguments you can use in relation to escaping the normal consequences of Part 36. As you'll see, on the whole, it's very, very difficult to do. And there's no reason to say the court wait for you if it's difficult to escape retrospectively, because you realise the case isn't as good as you thought it was. It should be any easier to escape that prospectively. More issues about Part 36. They get to do with time. The Meridian, the Home Office, doesn't ask for damages for unlawful detention. The defendant made a Part 36 offer of £50,000 3 days before the trial, and it's accepted a day before the trial. Now, if you make an offer less than 14 days before trial, and it's accepted, then the usual rules don't apply. They get the usual steers as to what should happen. So the defendants couldn't agree, or the parties couldn't agree, on issues in relation to cost liability and the matters placed before the judge on the basis of the written submissions. Well, the judge said it doesn't fall in the rules. The CPR 3613 doesn't set out any consequences of accepting within 21 days of trial. There's no helping any authorities in the White Book. Anyway, The lack of a steer doesn't mean there's an open-ended or an open-ended discretion. What the judge said is that if you are in these circumstances where you've accepted an offer and made less than 14 days for a trial, then you have to go back to the principles of CPL 44, general orders to cost. Looking at that, the judge said, I don't accept the defendant's argument that accept this offer on the door of the court almost means that the claimant should recover nothing. But I think there should be a percentage reduction. The real issue is what percentage reduction. And the defendant was obviously arguing for 50 or 65%. And the judge said, no, it's going to be lower than that. What is interesting there as well is in making that decision, the judge looked at the history of the offers. If they made an offer of £10,000, claimant didn't reply, made an offer of £40,000. 4 times claimant's original offer, and nearly 3 times what the claimant eventually accepted. So the claimant's offer was much higher than it eventually accepted. And I think you need to be aware of that fact that the judge will look at offers made and offers received, but if you just have to consider an overall discretion, because the judge in this case said the claimant strategy completely unrealistic, and I find conduct was justified as significant, not taking reduction, but 50% is too much, and the reasonable reduction is 33%. So, an overview of what happened if an offer is made late. The usual steers from a CPR 36 that apply. The principle that the party accepting the offer is can recover the cost of the date of the offer. If they offer within the time for acceptance. So the court looks at CPL 44, which is general rules as to cost, and conduct and history of offers could be relevant. But if you've got a case worth £50,000, but your first offer is £1 million, that could have an adverse effect later down the line. I don't think nothing wrong with being over generous or think about it in terms of an initial offer by the claimant, but it has to be with a band of reasonableness. Next, about the validity of a Part 36 offer. What if I make you an offer to deduct basically 1.15%, or an offer which effectively, in monetary terms, reduces the offer by 50%? Is that a valid offer? And here we have the case of Omni Unlimited Andrew. And in that case, what happened was the judge awarded £765,000 of damages. The claimant had made a Part 36 offer of 756, difference of 8,800. Now, really interesting there, but there was no doubt that Part 36 had been beaten. And the defendants argued, well, we shouldn't have to face the normal Part 36 consequences because, okay, the claimant's beaten its own Part 36 offer, but it was just a minor concession and wasn't really a genuine offer to settle. But the defendants failed to establish this sort of a general offer. It was an entirely sensible course for the commercial claimant to carry on, said the judge. The claimant was being genuine. It tried to achieve a settlement, and this was not, as in some cases, a cynical attempt to manipulate the scheme designed to encourage settlement. So, as a result of the claimant beating their own Part 36 offer, the claimant received another £63,000 plus for beating his own offer, and all the other benefits of increased interest and indemnity costs. Let's look at that. Look at that very carefully. The claimant offered to give up £8,807.35. It received £63 thousand, just over in return. Plus, it got in had interest at 5% over base, and plus indemnity costs. Well, that raises the issue: is that why can't that be done in every case? In a lot of cases, still claimants are going to trial without having a Part 36 offer in place. And there's going to be an argument at some stage that when those kind of sums are talked about, up to £75,000, claimant solicitor was negligent in failing to advise the claimant to make a Part 36 offer. But in that case, if nothing else exemplifies the advantages of making offers. We'll give up 8,800. You didn't accept our offer, we get an extra 63,000 in return. That's not a bad result for a claimant at all, the extra money. And as I've said, the real risk is that people aren't making offers enough or realistic enough to put their party at risk of trial. What if you've got a very complex, tangled issue? The case of Grant and others is about Part 36, and it's another technical issue. Basically, Lehman Brothers went into liquidation and into administration, and the administrators succeeded in their application. And they wanted a declaration from the court that when the administration end, the company was entitled to enhanced interest, and there was just tremendous amounts of money at stake, tremendous amounts, and they succeeded in proving, getting the declaration of order, that the interest was repayable to the claimant. During the course of the action, the claimant made a Part 36 offer of the money, and lo and behold, because it's basically an action on debt, really. Now, the claimant beat its own Part 36 offer. What the defendant said, well, this case was never really about the money. It was on the face of an application for a declaration. And but the reality was, the case was about a lot of money. You got the benefit of declarations, ended up with a farm and with a property. So there's a lot at stake. And what the judge found was that CPR 36 was engaged. The offer was Part 36 compliant, and the offer had been beaten. And I do not accept, as the judge, that these proceedings were not about the money. Plainly, they aren't always have been so. Question being whether the specifying the spots will become due on termination of the administrator's appointment. So again, be aware that an action might appear to be about the money, but in this case, despite what the defendant said, the claimant was entitled to recover additional damage in the Part 36. The other complication with this case is that the money was not due immediately. As a result of that, it was held not to be liable, or held not to be liable to pay interest from the outset because the money wasn't due. And because in any event, court interest wouldn't have been awarded interest as a matter of discretion. And also, because of the clear beating in saying Part 36, offer indemnity costs were awarded. So we've got the extra money and indemnity costs. We've got a bit of time off work as of a Part 36 offer. Now the next question, was the claimant entitled to the enhanced damages? I think the maximum of £75,000, which is actually a relatively small beer in this context. But the court said, no, I can't see any reason why it's unfair that the maximum figure be allowed. Maximum figure is £75,000, and that was allowed. So again, we see the importance of making a Part 36 offer, the things that can benefit from it, and the inherent damage and interest that can flow. And interest particularly gets elevated for base rate. It can have a major impact on cases that have been hanging around for years, mediated for trying to settle. Next point I want to look at is how easy is it to escape the consequences of a Part 36 offer. And again, the case of Vinyl Westos considers this issue. And what we have here is a case where claimants succeeded in the trial, recovered £400,000. They made two Part 36 offers. One was met by one claim had by £1,500, and the second rate of behalf of the claimant to £1,200. And the claimant had clearly done better than their offers. So what the defendant argues, they've done better, but the case wasn't argued. The Gordon Trust claim was actually pleaded at the time you made the Part 36 offer, and therefore it's unfair that we face the consequences of that offer, given that it was a pleaded claim at the time. It didn't matter because the case would have succeeded on another basis, which was pleaded, and so it's irrelevant to the outcome. And there's a formidable obstacle to the obtaining of a different cost order in a Part 36 case. So, in the fact that you've amended late made no difference in any to the court's decision on costs, because although the Gordon Trust claim hadn't been displayed at the time of the Part 36 offer, they didn't really play a large part in the trial. The claimants would have been successful even if that event hadn't been pleaded. And the rate of interest allowed was 4% above base, not for 4% of a base rate from the time of the order to the time of the order to the date of the file, date of the order. And what about interest on the compensation? Again, that's awarded at 4% of the base, and in both cases, the judge said this simple interest is going to be simple interest, not compound. I've said before, we've got here an award for an additional amount. They wanted 10% of the amount, £40,000, and that was awarded. And I want you to look very carefully at the test here, because we're coming back to this later on. The test here is whether it's unjust to require the defendant to pay this additional amount. It's not for the claimant to prove it, it's for the defendant to establish it's just for the normal consequences not to apply. So there is, if you like, a hint of the technical arguments around Part 36. And I want a particular look now about Part 36 offers and the cost process, the cost assessment process. Not only this interest in themselves, if you're a cost lawyer, you've got an interest in costs because you want to get paid, but they also show up other highlights of the Part 36 discretion. And there's the law, what about Part 36 offers and costs? And it's a case TRX Football Club and TRX and Southampton Football Club. And there was an acceptance of £4,000 in an action about sexual abuse. The matters went to assessment, the costs were reduced substantially, but the judge made no award for the cost of the assessment. And the argument there, and we'll see what this came up in when we look at the later case in a few minutes, was that we should have got our costs because the defendant could have protected himself by making an effective Part 36 offer. You didn't do that. You could have made that. You didn't, and therefore we should recover our costs. What the judge said, and this is important in this context and many other contexts, is that if the defendant had made a Part 36 offer, then there's no problem. So if the claimant had made a Part its offer had been beaten, there's no problem. If it's beaten by the amount allowed or the sum offer, then the judge can apply more or less usual Part 36 consequences. But the problem here was that the Part 36 offers were not accepted. So that's the issue here. What relevance the Part 36 offers or the absence of Part 36 offers play in cost assessment when they're not beaten by the paying party or the receiving party? And the judge said the absence of a Part 36 offer is a factor, but it's a relevant factor, but not necessarily the definitive factor. I don't accept, the judge says, the claimant's argument that it would be run for a judge to make no order. It would be a relevant factor, but not the most important factor. And it may be unusual to make no order for cost when no successful Part 36 have been made, but it all depends on the circumstances of the case. And therefore, the first instance judge was not wrong in principle. I do not accept, the judge says, the claimant's argument that cost Judge Brown order was wrong in principle. The claimant's argument also failed to address the difficulty for litigants in person who may have difficulty navigating the Part 36 regime. I remember the issue is that no one's made a Part 36 offer. The judge has decided essentially a plague on both your houses. You can have your costs as I assessed them, but you're getting the cost of the assessment themselves, and the decision to make no order for costs was upheld by the court. And I want to look now at another example of a defendant trying to avoid the consequences of a Part 36 offer of costs. And the case in Liverpool County Court, I think it was early last year, and I think myself and a colleague from Chambers arguing on opposite sides. What had happened there was that the claimants brought actions for disrepair against the defendant counsel. Each case is settled without a need for proceedings, and each claimant then issued proceedings for costs, and then a number of cases, 6, were listed together for the purpose of an assessment. After the court has ordered the assessment take place, in order they be heard together, so there were common issues in relation to the what was going on. The claimants each made a Part 36 offer, and the defendant accepted it. And this is important, though. The defendant accepted it outside the 21-day period. They did that quite deliberately. Court conceded, as we'll see in the hearing, they did that quite deliberately because they wanted to make an application for a different order for costs. That is, the claimants pay the defendant's costs. That's a serious application. It took all day in Liverpool County Court with a reserved judgment, and the result may look obvious in hindsight, but believe me, I was there, and it wasn't obvious the verdict of the hearing. Now, we can see there that the argument was made on behalf of the claimants was that to say there's a straightforward issue, the defendant's got a very high, heavy burden, and they're trying to undermine the normal consequences of Part 36 and the Part 36 consequences. Any party setting itself on the path of attempting to escape the norms of that framework bears a heavy and significant burden of persuading the court that their mind is the only route to a just outcome. So there's a really strong presumption which the defendant or the paying party has to display that the normal consequences apply. And the judge said, I was satisfied, not least satisfied because my colleague told him, that it was a deliberate attempt to avoid the normal Part 36 consequences. That they made the application to accept more than 21 days after the offer. It was a deliberate choice. And The judge went on to say, Part 36 is intended to be a two-way straight and narrow highway with significant limitation on escape lanes. And this particular case has come a long way short of establishing injustice and to overturn the presumption 36.13.5 that the receiving party claims in this case should recover their costs. So do be aware of a number of cases where particularly defendants are saying we shouldn't have to pay the normal partly consequences. They might be successful partly and in parts, but on a general rule, they are fighting very much an uphill battle. Another case I want to look at in relation to Part 36 and costs is UK sovereign investments. What happened there was that Action set up for 103,000. Detailed assessment proceedings were started. The claimant seeking £83,000 in costs. And the claimant agreed to accept £59,000. Now, the significance of this is because if it's under £75,000, you have to use a provisional assessment procedure. And assessment can be done on paper, it's a lot cheaper. And what the defendant argued was that there had been a policy trouble, but there should be departed from the principle that receiving party pay the claimant's costs. And what the judge said, no, whoa, I've not heard any evidence. I am not in a position to lay a finding that the figure about in the bill was exaggerated. Not carried out the assessment, not heard submissions, and I don't know why it was accepted that figure. And the fact it was accepted on the lower amount than claimed is not significant. I do not regard that the bill was claimed at 83,000, settled for 59, giving an inference that the cost claim must have been exaggerated. There may have been many reasons why the claimant would have discounted the bill, and right at the court, which was not know and will never be told. But taking these factors into account, I'm not persuaded the claim's cost should be limited to £1,500, which is the provisional assessment basis. And the court could make award of costs. Also, it's another example of a court considering the relevance of offers. He said, I find in favour of the claimant that he settled much closer to its own figure of £60,000 than the sum of £42,500 which the defendant had offered. And again, a very important observation here, that it was in the defendant's gift to make a realistic Part 36 offer at an early stage. And if you ask the defendants, remember this, because it is what judges will always turn around and say to you. It was within the defendant's gift to make a realistic Part 36 offer at an early stage. What the defendant can't do is seek to have a second bite of the cherry, having failed to make an offer on the Part 36 prospective. You can't go and say, well, no, we didn't make a Part 36 offer, but the case was so exaggerated over the top that we want an order in our favour. No, says the judge, the answer is to make an effective Part 36 offer. Don't come looking to me if you haven't done that and you're complaining about costs being incurred. And if it was the purpose of the assessment procedure to say that any case that started over £75,000, but which was reduced assessment to less than £75,000, would be subject to provisional assessment costs, then the rule could easily have said that. They say you have a context that you're limited to such costs. It doesn't say that, and therefore the jury allowed a claim to recover costs. The judge considered CPR 44 in relation to the factors in deciding about costs, but the judgment emphasises time and time again the best way for a paying party to present themselves is to make a realistic policy offer, which puts the receiving offer or the receiving party at risk. And I say it again without apology. The judgment emphasises the point that the best way for a paying party to present themselves is to make a realistic offer, which puts the receiving party at risk. So there's my review, and now what to do is kind of look at the conclusions, the practical things you have to take into account when we're considering this. Before I do that, because this is a webinar for Chambers, I thought I'd better just put in a photo of Harry to remind you of who the clerk of the cost group is. There he is, very handsome. I think it's probably better than trying to put the whole cost team up there. Harry is the best and but almost brilliant what of call if you need arguments or advice in relation to costs. So what I want to say in conclusion, and I can see you've got some questions going already, which is always interesting, that technical arguments about validity of Part 36 offers abound. You've seen some examples earlier on. You didn't serve it in time because of the judge had a reading there. You didn't serve it properly because you sent it by email. They're always going to abound, and because the people receiving the offers, facing part of the consequences, don't really want to face up to those issues. So make sure your Part 36 offer is in time. 21 days. You've got problems if you're running up to a trial date. Make sure you know the trial date starts a certain. Make it well. Give yourself plenty of time in relation to service of an offer. Make sure it is in the right terms. And the terms can be understood. My advice to people is always follow the form. It's very easy. And warn your clients, and this is very important, that even a modest discount in a Part 36 offer can be affected, by which I mean we saw earlier on that someone effectively offering a sum of money, which is 1.15% less than they were claiming, which they received, led to, it must have been over £100,000 if you add up the indemnity costs of the additional liability and the additional interest. Massive impact on the side of the claim because of a very modest discount. And the fact it's a modest discount doesn't seem to matter. The defendants or the paying parties got to establish it's unfair for the normal consequences to apply. And as you see, that is far, far from easy, which leads me to the next point. You must warn your client when you get a Part 36 offer that escaping the Part 36 offer consequences is an uphill battle. I know I've used the same analogy twice with the guy running a bar up a hill, because that is actually fairly accurate. There are some cases which have been tweaked at the edges in relation to Part 36 consequences, but it is very difficult. And on the other hand, it's probably negligent not to advise a client to make a Part 36 offer, even as a claimant or defendant. I still, remarkably, go to trial occasionally in case the defendant is not admitted liability when liability looks a bit dodgy, or has admitted liability or liability looks a bit dodgy, and not made a Part 36 offer. That is very unusual, very, very unusual. It does happen, which would seem strange. More common is for the claimant not to have made a Part 36 offer at all before he goes to trial, or to make a Part 36 offer which is so unrealistic that it's not going to have any practical reality or worry to the defendant. And I think you have to think very, very hard at some stage of the case, what is a realistic Part 36 offer? You have to tell the clients about the importance of it, what they could gain from it, and decide then with your own client what's the best way of making a Part 36 offer. And not just the best way, but the best amount, the most realistic amount. And the other point I want to make is that what I intend to do, I took you back to February last year, is date or provide one of these courses once a year, hopefully about the same time of year. So we'll be back here hopefully this time next year, except if there are any kind of major developments on Part 26 in the meantime, then it would be silly just to leave it until this time next year. If there are a number of big cases or one big case which is back to Part 26, I will bring it forward earlier to deal with those. I think a 12-month period, just for the sake of a 12-month period, doesn't necessarily follow. But I can promise that we will be watching or we'll be looking at Part 26 in the future. Now, I've got space here for any questions. Let's have a look. Right. What is the position if the claimant accepts the Part 26 out of time in the fixed cost matter? Now, anonymous attendee, that depends. Depends when it was issued, because we know I haven't mentioned quite deliberately about the question of Part 36 and quox, because we're on the cusp of a new regime, and I think we've got a lecture coming up, or we had a webinar on quox. Now, what is the position if a claimant accepts Part 36 out of time in the fixed cost matter? If it was issued after April, I think before April the 4th last year, you get your fixed costs up to the date of the Part 36 offer, and you're not liable to pay because of quox any costs thereafter. If it's issued after that, then you get your fixed costs up to the date of Part 36 offer, and you are liable to pay the defendant's fixed costs after the date period for acceptance, which will be deducted from your damages or costs. Right. Now, I would have thought this. We also get interesting questions about maritime cases on these webinars. I don't know what it is. Hi, where a Part 36 offer is accepted in a maritime case against one interested party, and it's actually been extinguished, can we commence DA proceedings straight away, or do we have to apply for a cost order? Well, I think what the rules say, and this isn't on a big, you best have a close look at the rules, because you need permission, I think, to accept Part 36 offer against one party, not the other. So I think it's best to go away and have a look at the rules about accepting the Part 36 offer when there are more than one party. You may need permission, you may need to sort it out on an order. Right, okay. If a claimant makes an offer for £15,000 pre-litigation, then limits proceedings to £5,000, probably to avoid a higher issue fee, can the first offer be considered to be a genuine offer to settle the claim? That is very fact-specific, and that the first offer will be a Part 36 offer, probably not. But the question will not really relevant to anything we're discussing today. The question will be, that may or may not be conduct, but it play a little part in the assessment of the costs if the claimant later makes an offer, Part 36 offer of £4,000 and beat that at trial. An anonymous attendant asked that question, a pre-litigation offer of £50,000, issuing limited to £5,000. I don't think it will have much relevance in the overall mix. Okay. In a fixed cost RTA matter, is the defendant entitled to the cost of the claimant accepts the Part 36 offer outside 21 days? It depends when you issue, because the quox regime changed last month. So if most of your ongoing cases, where proceedings were issued the 5th of April, maybe the 6th, quox continues to apply, and the defendant can't enforce its judgment. Or new proceedings after early last month, I should know the precise date, but I don't, then the defendant can set off its costs. And I think you've got to emphasize that, and I think I spoke about this in other webinars. The new regime, the defendant can set off its costs against the claimant's damages and the claimant's costs. So, Thomas, who's asked that question, it depends when it's issued, probably not to all your existing cases, anything issued before the 5th of April this year. After that, it's going to get very difficult, and you're going to be in a position where you're going to be asking or telling your client they're going to make very little, if any, damages that are recovered. Okay, I just want to make sure I've got all the questions. Oops, they're wrong. When seeking leave to appeal a county court judgment, can the defendant also make a Part 36 offer? I'm not quite sure what's going on here. You can make a Part 36 offer that covers an appeal. That can be a fresh offer, but yes, Part 36 offers apply to appeals. So, for instance, the defendant says, we think your case was worth £50,000, you got 100. Here's a Part 36 offer of 55. If you go to trial, if you go to appeal, and damages of the Part 36 offer is affected, you can still have Part 36 consequences. There's more questions coming in. Now, when C accepts a Part 36 offer late in a matter involving an incident, what are the cost consequences? Is it only costs following the offer which is seen liable, but not including the intended approval hearing? Well, that's even nastier. It was nasty before, it's always been nasty. Anonymous attendee, you want to go back and look at the webinar I did last year, because this precise scenario arose in a case of a High Court master. What happened was this, that the claimant issued proceedings, a very early Part 36 offer from the defendant, and many months later, a year later, the claimant wanted to accept the offer, so it had to apply for approval. Now, even under the all clocks regime, once you needed a court offer for approval, the defendant could set up its costs. So the claimant had to pay the defendant's costs or incurred thereafter. Now, the interesting question, which is the one that you're asking, that yes, they have to set up the costs. Did they have to pay for the intended approval hearing? I don't know the answer to that, if truth be known, because an intended approval hearing would have to happen in any event. The causation, but I don't know the answer. But I think it's very, very important to know now that the cost regime of set-offs, the Part 36 has always applied to cases where approval is needed, and it applies even more now to everyone. Now the cost regime has changed. I just want to make sure I've got all the questions. That's the ones there. There's some people coming in on chat that sometimes happen. Oh, yeah. Some more questions. I don't know why they arrive in a different place than they do. Oh, right. Poof. I'm going to come back there. Now, when a defendant wants to appeal a CRU, makes a Part 36 offer with regard to CR benefits, can the offer be made subject to the condition that if accepted, the claimant even discloses DWP records or formal authority to allow Lexis to the same, therefore allow the CRU to be appealed? This is still a valid offer. I doubt if it is, because you can't impose conditions on a Part 36 offer. You can't say, I want to pay this. An offer of that type would not be, or I'd say there's a 99% certainty, an offer that attempts to impose conditions would not be a valid Part 36 offer. Okay, someone's saying they have to leave. I'll go back and just check because more questions keep coming in. Oops. Right. So this is okay about the portal, anonymous attendee. If higher storage and recovery elements of the claim exceed £1,000, can we reprove the matter from the portal and claim CBR central cover? Well, I think, to be fair, this is the webinar about Part 36, and I don't really want to go off onto portal costs because many of the people watching this are PI lawyers. Right. And now, the question here from Joe. It's a Part 36 offer made by paying parties on certain terms. For example, in a housing case, repairs will be done in a number of days. If the claimant then accepts the offer, but in their responses change the number of days, is this a new offer on the basis of many terms? Well, you're not accepting it. You're making a counter offer without a shadow of doubt. I don't think that would be any doubt about that. You've accepted it in full, or you make a counter offer. In that scenario, you're making a counter offer. Well, are Part 36 consequences potentially avoidable? Is there is a very early Part 36 often made before any evidence is obtained in the case? No medical evidence. Is it arguable the claimant cannot be legitimately expected to die the case without evidence? Chris, I think that's a very good question. I did a webinar for another organisation for April about what to do, on that very title, what to do if the defendant makes an early Part 36 offer. I think it's still available. It's commercial, so you have to pay. Commercial organisation, you have to pay for it. But again, I think it depends. I think if the worst possible scenario, people are trying to avoid it. You've seen the case we looked at where people try to extend the time for acceptance. But I think there's a risk they might. What the case law says, and it's particularly clear in last year's webinar, when I look at this in a lot more detail, particularly clear in the webinar I did about acceptance of offers when they're made early, the courts are very sympathetic. You have to prove it's unjust. Now, there are cases when it happens, but I don't want to encourage you because they are very rare. You have to sit down with the information you've got to make difficult decisions. Decisions about what could this case be worth, what do we know, what don't we know. So it's not an easy task, but it could be effective. It could still be an effective Part 36 of it. But I think it's worth looking at the cases I looked at last year, and it's worth, Chris, if it's a real problem, looking at that other webinar. And also my blog, if you just search against Part 36 personal injury, all those cases are considered, and it's very fact specific, but it could still be an effective Part 36 offer. Okay. This is an anonymous attendee. If non-personal injury elements the claimant in the OAC settlements on the portal bill Part 36 and the claimant's claim costs. Yeah, again, anonymous attendee, I'm sorry to be awkward, but this is really a question about costing the part, not Part 36. And we will have webinars about portal costs, we will have webinars about fixed costs, and we have webinars coming about the fixed cost regime. But I'm not going to deal with those kind of portal issues on this webinar. Okay, they've been very interesting questions, and I don't think there are any more. Thank you very much for watching. It was designed to last an hour, but there's very useful questions. They've lasted an hour, and I hope to see you. As I said, I hope to be giving one of these every 12 months, unless there are major developments which make it worthwhile doing one earlier than that. Thank you very much for watching, and I hope to see you at some time in the future.